everyone, and welcome to the Immigration Insights podcast, hosted by Greenberg, Traurig, and our Business Immigration Group. My name is Kate Kalmykov. I co-chair the Global Immigration and Compliance Group at Greenberg, and I am your host. Today, we are going to kick off the new year by talking about the top 26 EB-5 insights for investors in 2026. So this is a blog post that has been posted on eb5insights.com. And I really, in the blog post, wanted to highlight what you should consider if you're going to be participating in the EB-5 program this year. We're going to follow it up with a robust discussion today with my colleague, Jen Hermansky, shareholder in our Philadelphia office, and who has been with us for over a decade doing EB-5. Hi, Jen.
Hi, everyone. Thanks for joining us today to talk about our updates on EB-5.
So let's get right into it. And I know you have a lot of unique insights, not just from our practice here at GT, but also in your position as chair of the AILA EB-5 committee. Of course, the top issue this year is that grandfathering will expire on September 30th, 2026. So what does this mean for investors, and why is it so important for them to file before the state?
So when the Congress passed the EB-5 Reform and Integrity Act of 2022, they protected investors who file I-526E petitions by September 30th, 2026. And if an EB-5 investor makes their investment and files their I-526E petition before September 30th, 2026, then they can continue always in the process for the EB-5. So they can have their I-526 approved, they can get their 2-year green card, they can file their I-829 and get that approved. And that is regardless of whether Congress further extends the EB-5 program. And the EB-5 program, the Regional Center program, is set to expire currently on September 30th, 2027. So essentially, filing your case 1 year before the expiration of the program will protect you in the event that Congress does not extend the EB-5 program beyond that date.
We also expect that there will be a price hike. They may change TEA requirements. They may change how jobs are counted. So grandfathering is really going to be key. And we're probably going to do a separate podcast to discuss what happens if you file after grandfathering expires, but before the program expires. Now, number 2 is act before potential price hikes. There was a court case in 2025 which took the EB-5 fees and reduced them substantially back to where they were before the latest fee increase by USCIS. But that's temporary. So investors may see an increase in filing fees.
Yeah, that's correct. And recently, the USCIS actually published a fee study and a rulemaking to make new regulations on fees also. So it's likely that that will become final. There might be some change to the USCIS filing fees. So right now, there is a significant reduction from what they were just a few months ago. So now is still a good time to file.
Tip 3. File early to avoid retrogression delays. EB-5, prior to the passage of the Reform and Integrity Act of 2022, was severely backlogged for China and India, and at one point for Vietnamese nationals, because individuals from those countries overused their allotment in the program. And since the passage of the RIA, we have not had retrogression, but the threat is always looming. The Department of State has warned us if they process visas quickly enough that retrogression may occur, particularly for nationals of China or India who have filed in the special visa categories such as TEA or rural.
That's correct. And we believe at this point that there could be a backlog announced sometime in the middle of 2026. And so for investors that are seeking to file their case, and if they are physically present here in the US, also seeking to file the I-485 to protect any children from a potential age out, these considerations are really important because right now we have Chart A being current under the visa bulletin for all countries in our set aside categories, but that might not be the case throughout the entire fiscal year. So it's a good consideration to talk with your lawyer about whether or not you're born in a country where the visa backlog might affect your processing.
Tip 4, submit a well documented petition. I would say we have never seen the types of RFEs, noids, or denials that we are seeing in 2025 and into 2026 from this administration. And interestingly enough, they are going straight to denial in some cases. So submitting a well-documented petition in 2026 is going to be key. What kind of documents, Jen, should clients who are going to be filing applications, who want to make sure that their applications are not denied, that they get the grandfathering benefit and the ultimate approval, what should they be doing?
As far as the investors are concerned, USCIS has stated now a number of times in their adjudications of cases that key documents include at least 7 years of tax returns for the investor and for the other individuals who are involved in the source of funds. So, for example, if the investor receives a gift or a loan from a person or another company that's not a bank, the USCIS wants to see at least 7 years of tax returns from those individuals or those companies that might be involved in the source of funds of the investor. They also are very focused on getting the business license of any company involved in the source of funds. So maybe if the investor owns their own company and that's part of the source of funds, even an employment by a foreign company abroad, the USCIS seems very focused on receiving the business license, probably so they can evaluate whether or not the investor has any ownership interest in that business. So those are really key. And also the investor providing a personal statement that they have not been involved in any criminal cases in the past 15 years. And also they have not been involved in any civil litigation disputes in the past 15 years. These are key points now for the USCIS.
And Insight 5 was actually to provide comprehensive tax filing. So you covered a good portion of that. But one of the things that we have seen in some denials and that other practitioners have reported is that now USCIS wants to see if you're from a jurisdiction that doesn't require a personal tax filing, think UAE, think Singapore, that you have to, in the negative, prove that you are not obligated to submit a tax filing, whether it's a letter from an accountant supported by an excerpt of the law.
And not just that, Kate, they're also focused on having the investor provide tax returns from other jurisdictions. So, for example, if an investor is a business person residing somewhere in the UAE, but they're also a citizen of India, the USCIS seems focused on also asking for tax returns from India or other countries where the person might have lived and worked or been obligated to file a tax return in another jurisdiction.
Okay, Insight 6, include complete business registration records. The USCIS wants to know where this money is coming from. So they want to see your formation documents, they want to see corporate filings, licenses, shareholder agreements, everything you have related to the business, whether you're taking a loan from the business, your income is sourced from the business, they want to see that documentation. Okay, Insight 7. And this is really, I think, coming from our expertise in preparing so many 526 cases, is really reconsider using an old source of funds. Oftentimes, with the passage of time, documentation just is no longer available. Bank accounts close, transaction documents get lost, and this is just not the time to file a source of funds that may have documentation missing or has a hole in it. Jen, what do you think?
I think that's right. The USCIS is now very focused on what I would say is the origin of the money. So if an investor is using a house as the source of funds, maybe selling it or taking a loan, they're very focused on when and how that property was purchased. Even if that was 30 or 40 years ago, the USCIS is routinely asking about employment documents, tax returns, even bank statements from that long ago. And so it's very difficult for investors to go back that far to obtain the documentation about their employment history from so long ago. So this is definitely a strategic point of what is the best source of funds to use based on the amount of documents you'll be able to turn over in any request to USCIS.
Exercise caution with loans. Now, the RIA codified that an investor can use loan proceeds to make their EB-5 investment. But one of the things that we have really seen become popular after the passage of the RIA is regional centers, developers offering sort of loan programs through their affiliates, sometimes in conjunction with a bank, with a third party. And sometimes these loans are available through the new commercial enterprise or the project itself. And USCIS is definitely scrutinizing those cases. I think they feel uncomfortable with them. And I think there's sort of a gut instinct that maybe that's not a bona fide loan. Why would the new commercial enterprise that is seeking investment from an investor also provide a loan to the investor? And it's raising a lot of questions, particularly in adjudications. So definitely speak with counsel before you use that as the source of funds. Now, number 9 is something, Jen, I'm going to toss over to you because we've been dealing with this a lot. Avoid installment funding.
Yeah, this is a really hard one because actually the statute, even in the RIA and the statute that was passed, back in 1990, all of the statutes provide that you can be in the process of investing. And the I-829 regulations from USCIS also say you could have been in the process of investing and then even up to the time of filing the I-829 show your full investment in the new commercial enterprise and therefore into the project. So all of the guidance in the statute and the regulations, as well as the USCIS policy manual, says you can be in the process of investing. But recently, USCIS has been very aggressive with this interpretation. And even where an investor has some finite amount of time to make a second installment towards the full $800,000 investment with the new commercial enterprise, USCIS has now repeatedly said in some denials that they are not bound by any timeline between the investor and the NCE that is agreed upon. So we think if you're going to use the installment method, this is one area where you definitely have to work with experienced counsel. You have to document when you're going to fund the rest of the investment. And importantly, USCIS is now saying you need to document the full source of funds upfront, even for that other second installment that you intend to send later. So this has to be done in some form of moderation where you're planning, what the second installment is going to be, and you're submitting those documents up front, even if you're going to wire the remaining funds later.
Number 10, document all capital transfers thoroughly. So, we have always had a requirement not just to explain the source of funds of the EB-5 investment, but also to trace the funds all the way from the time that they were earned to investment with the new commercial enterprise. And so now more than ever, it's so important to keep copies of bank statements, wire transfers, and really all the documents in the chain of funds to prove where they originated. Now, number 11, and this applies to a lot of investors from China, from Vietnam, and it deals with Communist Party issues. We have to address those now proactively in light of the changes from the administration. Jen, can you elaborate on that?
Sure. This administration changed some of the exceptions for Communist Party membership and when investors or their family members will remain eligible to get the 2-year green card. So previously, there was an exception for non-meaningful membership, meaning if you were just a regular member, of the Communist Party, you did not hold any positions or other, roles of authority. Generally, that sort of baseline membership where you don't really subscribe to the party's ideas and you hold no roles within the party, you are still considered admissible to the US, meaning you could get the 2-year green card. But the non-meaningful membership exception was taken away by this administration. So now generally, if you have been a member of the Communist Party within 5 years of getting the 2-year green card, then you're going to be found inadmissible. So it's important that you disclose to the lawyer that you're working with about any Communist Party membership so we can evaluate whether or not it's likely you'll be eligible for the 2-year green card, or also maybe whether a spouse should be the main investor in that case. And maybe the spouse and the children are still eligible to immigrate now. So there are some options there, but you need to discuss fully with the lawyer.
Okay, tip 12, perform rigorous due diligence on regional centers and their projects. This has always been the case in EB-5. You are making a business investment. It is $800,000. You need to know who you're working with. What is the track record of the regional center? Have they been filing their annual compliance filings? Do they have projects that have been denied? Do they have a track record of 829 approvals? Do they have a record of repayment to investors? And same thing with the project. Is this their first development project ever for the developer? Or do they have a track record of doing commercial real estate projects in the geographic area where they're building, in the space that they're building? Have they ever built something at the size, the ticket size that they're seeking investment for? Who are their partners? Who are the principals of the project? What are their backgrounds? And the same thing with the regional center. There is some comfort after the RIA was passed that they're doing their own background checks, but that doesn't mean that scandals can erupt after filing. That doesn't mean that projects don't fail. So you really, really want to do due diligence, and you may want to work with a licensed broker dealer to have them really review the financials and the documentation of the regional center, the project, and the developer. Okay, the next section of insights deals with adjustment of status and immigrant visa processing at the consulates. And of course, this was written before the ban was announced last week by the administration that 75 countries would have their immigrant visa processing temporarily paused at the consulate. So this is green card applications at any stage in the NVC process for 75 countries are currently paused. They will accept documents, they will schedule interviews, but they are just not issuing green cards or immigrant visas. It does not apply to adjustment of status applications in the United States. And it's temporary. So monitor our blog, eb5insights.com, to see when it will be lifted or if this temporary ban will be expanded to more countries. But the goal of the ban is to change the guidance on public charge, which is basically people coming to the US to take benefits, public benefits, means tested benefits like Medicaid. And so the administration wants to stop that. Now, of course, if they had announced it and said EB-5 immigrant visa applications by their nature are exempt because people have to show their net worth, people are making a substantial investment, that would have made sense, but they didn't. So there is a temporary pause for nationals of certain countries. In light of the pause, and just in general, Jen, the RIA gave us the ability to file concurrently for the first time. So if you're in the United States and you're in valid status, you can file your adjustment of status and your EB-5 application at the same time. So Insight 13 is consider concurrent filing strategically. And this is even more important now in light of this temporary ban because more people may want to travel into the United States and take advantage of the ability to file an adjustment of status. So what do we need to think about in that process?
Well, in order to be eligible for adjustment of status, you need to be physically in the United States. You need to have entered lawfully, and you need to have entered on a valid visa. You need to be maintaining your underlying status. And if all of those things are true, then generally we may be able to file the I-485 concurrently at the same time as the I-526E. So there might be some exceptions to this rule depending on the status that the individual entered the United States on. There might be some restrictions for people who are visitors or things like that, or some time constraints. So each analysis is really case by case based on the circumstances of the individual. But generally, for those individuals who are lawfully present in the United States, it may be possible to file the adjustment of status here.
And of course, one of the benefits of that is that you get to remain in the United States while the adjustment of status is pending, and you get work and travel authorization issued to you. Now, Insight 14, and you just mentioned it, is maintain an underlying visa status. That's not always going to be possible for certain individuals, for example, those that enter on a visitor visa, because visitor visas are limited to a 6-month entry. But because we have seen so many denials without a request for evidence or a notice of intent to deny issued, allowing the applicant to cure any deficiencies or perceived deficiencies in their applications, it is our suggestion that if possible, for example, if you are on an H-1B non-immigrant work visa or an L-1A intracompany transfer visa, that you maintain that status while the adjustment of status is pending, because the administration is changing adjudication standards ad hoc without issuing guidance, and this will really help you if there's any problems with the application. Now, Insight 15, track the visa bulletin movement and country-specific limits. We talked a little bit about retrogression already, but Jen, if retrogression occurs, obviously there's different consequences, whether you're processing at the consulate versus filing an adjustment of status. And why do applicants need to track this?
So generally, you can't be approved for a 2-year green card unless your priority date is current under Chart A of the Visa Bulletin. So that is the document released each month by the State Department to track the visa backlogs that are based on the country of birth. So generally, it's really important to track these because, number one, it impacts when people can file the I-485 application. So right now, the set-aside categories of the rural projects, the high unemployment TEA projects, as well as the infrastructure projects, they're current under Chart A of the Visa Bulletin, meaning anyone can file the I-485 application at this time, regardless of their country of birth. If we do get a visa retrogression for either mainland China or India, then that would be announced on the visa bulletin, and it might impact individuals' ability to concurrently file the I-485. And for anyone whose I-485 is still pending at USCIS, then a period of retrogression may impact when the I-485 can be approved. So we monitor that. There's also a chart B of the visa bulletin where sometimes we can file an I-485 adjustment of status application based on chart B of the visa bulletin. However, no 2-year green card can be approved until the priority date becomes current under chart A, even if you are allowed to file the application under chart B. So again, we follow these every month to see if we're going to get a backlog. Right now, none has been announced by USCIS. So it is fine to continue filing the adjustment of status here in the United States.
Okay. Insight 16, keep documentation organized for consular interviews. This seems obvious, but we cannot tell you how many times clients go into the interview and they don't remember what regional center or project they invested in. They don't remember and haven't reviewed the details of their source of funds. They may be incredibly high net worth. They may have income coming in from multiple sources, and they don't remember what they used for their EB-5 applications. Now, consular officials are taught and trained to root out fraud. So when you can't remember what projects you invested into, when you haven't reviewed documentation about your source of funds and how money was transferred, it sets off warning bells. They shouldn't be re-adjudicating an EB-5 application because it has at that point been approved by the USCIS, but they are entitled to ask questions. And if they suspect there's any kind of fraud, they can recommend a revocation of the EB-5 approval. Or you can slow down your case and get what's called the 221G notice issued for additional documentation, because consulates right now are charged with rigorous vetting and background checks, and they expect you to come to an interview prepared. So please organize your documents, review them. And Insight 17 piggybacks on that because it is expect potential delays due to security checks. This administration has been very vocal in saying that they are reviewing the backgrounds of everyone coming into the country, particularly as immigrants. And obviously, there is a lot of AI and technology at work in reviewing people's background checks. But if there is a hit, for example, a name check, some kind of previous criminal issue, overstay issue, an issue where you worked without authorization, that needs to be cleared by a human being at the Department of State or the FBI or another government agency, and it can trigger a delay. So expect delays after your consular interviews, perhaps during the adjustment of status process as applications are being reviewed. Now, Jen,
don't forget also, they're reviewing the social media too. So another reason why we're seeing sometimes some 221Gs is based on a review of the social media accounts. So proactively making those things public for the consulate is very important.
Absolutely. And deleting past social media history isn't going to help you. What's out there is out there. You're going to be reviewed on it. And you can expect if there's something controversial that they will ask questions. Now, Insight 18 is disclose status violations, unauthorized work, or criminal issues proactively. We just talked about how it can cause delays. We talked about how they're using AI very rigorously to scan for all of this. But if you don't disclose, it's even worse. Why? Because then we may be dealing with you're committing fraud in your immigration application because you haven't disclosed. And it's not status violations that happened in the United States. It's in your entire history, right? And that's what the government is looking for. So you have to be forthright. You have to present documentation related to any arrests or criminal issues at the outset to avoid delays and ensure a successful application. Now, Insight 19 deals with somebody who's already gotten their green card and they're spending a lot of time abroad. So apply for a reentry permit for extended travel. Jen, why do we recommend that?
There seems to be maybe some confusion about the rules surrounding permanent residence in the US. I think a lot of people don't understand them properly, but generally the government expects a permanent resident to be living in the US at least 180 days out of the year, and that's each year. Sometimes that gets confusing to people. They think maybe they can just enter 2 times a year and that maintains their residency, but that's not actually the rule. So we always discuss with clients that what are your plans for remaining in the US? Do you need to take care of some things abroad? Do you need to wrap up business or schooling abroad for your children and then you intend to move here? Because getting a reentry permit is advance permission from the Department of Homeland Security to spend longer periods of time abroad. And this helps you to protect your permanent residence from a DHS finding that you have abandoned your permanent residence by spending too much time abroad. So we think that applicants should always err on the side of caution here. When in doubt, apply for the reentry permit, explain what you're going to be doing abroad, and we show your ties to the US. Maybe you have a house here or lease, bank statements, other assets. We show your continued ties to the US, and then this will help to show that you have no intention of abandoning your permanent residency, even if you're going to spend a longer period of time outside the US.
Absolutely. The requirement is not enter once every 6 months, which is what the misconception is. I don't know how that happened, but it's a worldwide misconception. That is not the requirement. Okay. Insight 20, renew EAD and advanced parole documents proactively for people who have a pending adjustment of status. So the administration earlier this year lessened the issuance time of these documents from 5 years to 18 months. And they're taking a long time to process them. So previously, they had automatic EAD renewals. If you filed before your EAD expired, you could keep working while the renewal was pending. They have done away with that as well. So if you don't want to break in your work authorization or your travel authorization, file at that 6-month mark, which is the earliest you can submit an EAD or AP application. Insight 21, and now we're getting into the I-829 category, is prepare early for the I-829 filing. We can't tell you how many times people come to us, they haven't been in touch with the regional center, they haven't been in touch with the project, and there have been bumps along the way, and they just learn about it at the I-829 stage. You need to be making sure the project is moving along. You need to make sure that your funds have been dispersed from escrow and put into the job creating entity by the new commercial enterprise. You have to make sure that the project has made progress in their business plans. And if there have been delays, that we can explain them to the USCIS. A delay isn't necessarily fatal to an I-829 application, but it can have serious repercussions, and it can definitely delay an I-829 approval. It can result in a request for evidence or a notice of intent to deny. So you want to be in touch with the regional center and the project continuously during your conditional residence period. Now, Jen, Insight 22 is align I-829 filings with original investment documentation. So many times we get RFPs that flag inconsistencies. Can you talk a little bit about that?
Yeah, so we do see the USCIS asking and checking submissions. I would say now, in 100% of the time, they are going to review the entire EB-5 file at the time of the I-829, and that includes any I-526 petition that was previously filed. So we've talked about this before on our blog and in other podcasts that they are going back and looking at the source of funds and the path of funds from the I-526, and they will raise additional questions about that in the I-829 stage. So it's very important to, describe everything consistently as it relates back to the original investment. That also includes the project materials. So there's a lot of work to be done at the 829, and that goes back to the previous point. Start early so we can make sure that there's no problems leading up to the filing.
Now, Insight 23 is consider mandamus for excessive I-829 delays. So I-829s used to be adjudicated super quickly, and that made sense, right? You submitted proof that jobs were created, your funds were invested for the requisite amount of time, you get your permanent green card. After COVID, everything went to hell in a handbasket, to put it mildly, and I-829s have been taking 3-4 years to be adjudicated. There is a way to get it quicker. File a mandamus in federal district court through your counsel, asking the court to compel the USCIS to adjudicate the application. There is in the regulations a requirement that the I-829 is adjudicated in 180 days. USCIS has not been following that. So the courts consistently rule on the side of investors in the mandamus actions. And even before you get to a hearing, almost 99% of the time, the U.S. attorneys will settle and require that the USCIS adjudicate the case just to get it off their docket. So definitely consider a mandamus action. They're extremely effective. Insight number 24 is planned travel around the issuance of the I-829 receipt notice. So many times you have 90 days to file the I-829. They wait until the last minute, and then they have travel booked. And now we have a problem because the green card is expiring. And the receipt notice, which actually extends your work and travel authorization in the United States while the I-829 is pending, has not yet been issued. And we get frantic calls all the time saying, I have to leave, I don't have my receipt notice. And Jen, they're taking quite a while to be issued, aren't they?
Yes, I would say the lockbox is taking between 30 and 60 days to issue the original receipt notices. And it's very important that the investor get the original receipt notice. They do require that at a point of entry into the United States. So an investor needs to have their original I-829 receipt notice extending their status for 48 months, plus their expired 2-year green card. If either one of those documents gets lost or stolen or misplaced, then neither of those documents can be used to come back to the US. And the investor needs to actually go and get an I-551 stamp in their passport from the USCIS. So once you do get those documents from USCIS, hold on to them in a safe place because they are generally not replaceable.
And file your I-829s early. Don't initiate the process too late. If you don't want to break in travel authorization, you have to be proactive. Moving on to naturalization and Insight 25, track residency requirements for U.S. citizenship. We just explained in the reentry permit section that the residency requirement is 180 days a year in the United States. And to apply for naturalization, an EB-5 investor is eligible 5 years after getting their conditional green card. So that's when you start your look back period. Now, if you're spending a lot of time overseas, you got the reentry permit, you're probably not going to be eligible to NATS until you can come up with half the time spent in the United States prior to applying for naturalization and a 5-year look back period. Some people need to stay abroad for a period of time, 5 years, 10 years, then they come here, they start tracking, and they'll apply successfully for naturalization. But you have to track. People don't track. They change passports. Not everybody stamps passports anymore. When you're coming in, for example, to the EU and moving between countries, you're not getting a passport stamp. Keep a spreadsheet. Keep your travel reservations in a file handy so that you can put it together for your naturalization application, because they're looking at this incredibly closely. And if any trip is over 180 days a year, we need to know the circumstances surrounding that, because they're very focused on that as well. Now, to wrap up, Insight 26 is prepare early for the naturalization interview and civics and English test. So this administration came into office and they changed the examination. They made it longer. More questions have to be answered and answered correctly. They added questions. They made it more difficult. And this is in line with their public policy of really ensuring that people get naturalized who are committed and, tied to the United States through the language, through knowledge of the history, besides their physical presence. So to wrap up, it's an extremely exciting year, 2026, for EB-5. We have grandfathering. We have the price increase and change to the program after 2026 on the horizon. And we are really looking forward to working and assisting our clients in getting their applications in doing so successfully. EB-5 is still the best way to self-sponsor for a green card for high net worth foreign nationals. As many of you know, the gold card was introduced in 2026. It is much, much more expensive. It requires at least $1 million investment per family member, and it is not passed by Congress. So it may be subject to challenge. And EB-5, while it's effective, remains the more popular option. So Jen, what are your closing thoughts?
I think for investors who are thinking about starting the process now is the time. As we discussed throughout this podcast, there's a lot to be done to select a project that you want to invest in and all of the due diligence that comes along with that, plus the preparation of the source of funds. That is becoming more challenging, more document heavy. So the more time you give yourself leading up to September 30th, 2026, the better position you will be in. And also, if you are from mainland China or India and you could potentially be subject to a visa backlog and you want to file the I-485, then that is also a consideration to try and work as quickly as possible to get that done before anything is announced by the State Department.
Wonderful. Thank you so much for joining me today, Jen. Thank you to our clients. We've included a link to this piece on the blog on this podcast. And if you have any questions, feel free to contact either of us. Thank you.